Now, on the back of former Deputy President David Mabuza's estate battle, we look at the importance of estate planning, the difference between life insurance and pension fund, and what rules apply to each. I'm now joined by Banda, who's a financial planner at Capital Wealth Counsel. Edward, thank you so much for joining us this evening. I think if we could just start by, I know we have a Wills Week in South Africa as well, just to highlight the importance of a will. But if you could just take us to the basics and the importance of estate planning.
Good evening, Masa, and good evening to the viewers. Thank you for having me. Yes, you're right. The month of September was a National Wills Week, and I think the legal council or legal societies were pushing a huge drive to encourage South Africans to make time to draft wills and ensure that your affairs are on paper and things go according to plan. Like from your introduction, like you did mention, there has been a lot of headlines around the late Deputy President's estate. And for me, I think beyond headlines, this is a powerful reminder for all of us to consider and understand the importance of estate planning, which I guess we're here to discuss. And just as a form of introduction, estate planning or explanation to what it means. Estate planning isn't just for the wealthy or elderly, because I know that even in my work, we do come across young people that are starting out in their career and they do not see the importance of planning their affairs. And the myth is people think it's only for the wealthy or when you're old enough to start preparing for the end of your life. Essentially, it's for anyone who wants to protect their loved ones and ensure that their wishes are respected when they are no longer here.
And I also appreciate the fact that you mentioned that across the board, people should be considering estate planning despite your financial circumstances. It's not only for the wealthy, because even though we are seeing it playing out in the news and in the courts when it comes to this 44 million rand payout of the former deputy president. These are cases, Edward, that happen almost on a daily, where families are left distraught because there wasn't proper recording of what the deceased would have loved. If you could just explain to us some of the implications of not having your affairs in order and what that looks like. How does that transpire?
So, according to South African law, if you pass away without a will, for instance, your estate will be distributed according to the Interstate Succession Act, and this may not reflect your true wishes. What that means, basically, interstate succession, it's part of the law where the state has formulated steps in which your assets will get passed on. So if you pass away without a spouse, your parents could share part of your estate together with your siblings, or if you pass away with children and you're married, your family and your kids will have a portion of that estate, and your parents and your siblings or your brothers and sisters could also inherit. So you find that it creates a lot of ambiguity, and it also delays the process, legal cost as well as conflict in the family. Where people that were not supposed to inherit could end up inheriting. So it makes having a will in place significantly important to make sure that your assets are distributed or they go to the people that you had wished to pass those on to.
Mm. And when it comes to your spouse and your children, for instance, if it's not put in a will and your spouse, you have a customary marriage, but you weren't married in the traditional sense of going to the home affairs, but you got married in the traditional sense of customary law, where does that leave you when it comes to matters like this? And there is no will in place, but you're not legally married for the spouse and those children as well.
So normally customary law always defaults to the community of property regime, marital regime, where your spouse and the deceased will have to share those assets equally. So essentially they divide, 50% goes to the spouse and the other 50% will then get shared by the surviving spouse and their children.
And
so again, creating unfair distribution if the wish was for you to leave your assets to other heirs. Hence, always important to have these things written down.
yeah, and in the case when the deceased has been married more than once or twice and there's contestation regarding the kind of marriage that it is as well, can this be mitigated through just having a normal A4 size page will that has been documented to say, even though this separation hasn't legally happened or is happening still, and I'm still now with somebody else or I've moved on to the next spouse, does that need to be documented in detail? So
Absolutely. I mean, like the will, if you know that most of the viewers would have heard, the will is always referred to the last will and testament. It's the last word that the deceased speaks, and whatever is written on that paper should be followed through by the courts or the executor and the people responsible to unwind the estate. So it actually clears all the ambiguity where one has the opportunity to so to speak, give direction as to who should inherit what. And obviously, in terms of financial planning and estate planning, there's so many things that needs to be considered because there are certain instances where the will alone does not govern or give direction as to how assets get distributed, as in the case of the former deputy president, where had even, let's say for instance, he had a will that specifically left the funds that were sitting in a living annuity to a specific individual. The product or the vehicle that he invested in, a living annuity essentially, it's an investment where one would transfer monies from pension funds and retirement funds into this living annuity vehicle, which will in turn pay that individual a monthly income. However, living annuities are governed by the Long-Term Insurance Act, and pension funds are governed by the Pension Fund Act. So by basically moving money into two different vehicles, you'd find that the individual that's sitting in a living annuity has the opportunity to nominate a beneficiary who's entitled to receive the balance of the funds at the time of death. Sure. Therefore, my will could be leaving monies to my parents. However, if my parents are not noted as beneficiaries on my living annuity, as an example, the nominated person on that particular document is the one that legally entitled to receive these funds. If we look at the Long-Term Insurance Act that governs this type of investment vehicles.
But then, in the case as we're seeing playing out now, can then that family that is not then covered for in that living annuity, but also is covered in the will, then go and contest that?
So I think it's probably the reason why the judge requested the families to sit down and negotiate the terms of the distribution, because legally, if you look at the legislation that governs that particular investment product, only the beneficiary is entitled to receive the funds.
So that does make it quite complicated indeed then.
Absolutely, absolutely. And hence families are fighting. There's legal costs that are being involved, which could have been avoided had there been a careful estate plan in place to where one has the opportunity to understand the investment vehicles that they are invested in and be able to make an informed decision and a choice as to how those funds needs to be distributed. I'll give you an example, right? If you were to compare one individual that's invested in a pension fund versus another individual that would then go out in the market and buy a life policy. They may seem similar, but legally they are very different. I mean, a pension fund is a retirement saving vehicle, usually through your employer. So if you're self-employed, you're not gonna have the opportunity to belong to a pension fund. And because the pension fund is governed by Section 37C, as I mentioned in the beginning, that means that if you name a beneficiary in your pension fund at work, the trustees of the pension fund still have the final say as to who must receive those funds. Equally so, your will would not supersede the pension fund's trustees as to who must benefit. And usually in terms of consideration, they need to consider who are your financial dependents and distribute the money fairly. So in the case of the former deputy president, had his monies, the 44 million, had it been sitting in a pension fund, the conversation would be different because the trustees of the pension fund will have the opportunity to investigate who the financial dependents are and then distribute those monies equally or fairly in accordance to who needs the funds the most.
Yeah, thank you for that explanation as well between life insurance and pension fund. To Edward Banda, I really appreciate your time